The Senate Committee on the Judiciary will come to order. Mr. Secretary, please call the roll.
Senator Flores, or Vice Chair Flores, I suppose.
Present.
Senator Orangel. Senator Lang. Senator Nguyen. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
Please make sure that we mark Chair Scheibel and Senator Nguyen as absent excused, and please mark them as present should they join us a bit later. Please let the record reflect that we do have 6 members present. We do have a quorum. Good afternoon. Welcome everybody to the Judiciary. Our chair, unfortunately, is committing, and we are in that time of session, as you all know, where members will be coming in and out. Some are being summoned to present bills and or being pulled into different meetings. Please don't take that as a sign of disrespect. And we're hoping to have our chair joining us a bit later today. We will be taking the agenda a bit out of order, considering that we do have Majority Leader Jauregui here. And then afterwards, I anticipate having Assemblywoman Miller join us, and then afterwards, Assemblymember Roth. With that, I'm going to go ahead and open up the hearing on Assembly Bill 194. Majority Leader, good afternoon. Welcome whenever you're ready.
Good afternoon. Thank you, Vice Chair Flores and members of the Senate Judiciary. I apologize for my tardiness. I also had to make sure my committee had quorum, so I had to stay there while they took attendance, and then I rushed down here as quickly as I could. I'm Sandra Jauregui, and I proudly represent Assembly District 41. I'm happy to be here today to present Assembly Bill 194, which seeks to address the environmental and public safety risks associated with the intentional release of balloons inflated with lighter-than-air gases. Balloon releases, while often symbolic, pose significant environmental and safety hazards. When released, balloons frequently end up as litter in waterways or natural habitats, where they harm wildlife and contribute to microplastic pollution. Mylar balloons, in particular, are non-biodegradable and can cause power outages or fires when they come into contact with power lines. According to NV Energy, balloons have caused dozens of power outages in Nevada over the past 4 years, including one in North Las Vegas that left 12,000 residents without power. Recognizing these risks, other states and local governments have enacted similar restrictions, including the Las Vegas City Council, which passed an ordinance banning outdoor balloon releases due to their environmental impact and risks to critical infrastructure. In 2023, we passed Assembly Bill 321 to regulate foil balloons by requiring weights and banning conductive strings. Assembly Bill 194 complements these efforts by addressing intentional balloon releases statewide to further protect our environment and infrastructure. The reason I am bringing this bill is because a constituent 2 years ago reached out to me concerned about the issue. We couldn't get a bill 2 years ago during the 2023 legislative session due to time, but 2 years later, she did not give up, and she reached out to me again very early on, and here we are. It brought me joy to have my constituent Nicole Bott present with us in the Assembly and to be able to fulfill her mission to help make a difference in her community. With your permission, Chair, I would like to summarize the provisions of the bill and then turn it over to my co-presenters. Assembly Bill 194 prohibits any person from intentionally releasing, organizing the release of, or causing the release of balloons filled with a gas lighter than air. A single civil penalty of up to $250 applies for violations of this provision. Civil penalties may be enforced through actions brought by the Attorney General, district attorneys, or city attorneys. Any penalties collected are directed to either the State General Fund or local treasury funds, depending on which entities initiates the enforcement action. Additionally, enforcement authorities are empowered to seek injunctions to prevent further violations. The bill provides specific exemptions to ensure practicality and fairness in its application. Exemptions include hot air balloons that are recovered after launching, balloons that are used for governmental or scientific research projects, balloons released indoors and that do not escape into the environment. Chair, I have two co-presenters with me. I have AJ Reese with Nevada Energy and City Council Member Nancy Bruni, who I would like to thank for working with me on this bill and helping me model the language after her city ordinance. With your permission, I would like to first turn it over to my co-presenter from NV Energy.
Good afternoon, welcome. And before you get started, I do want to take a personal point of privilege and recognize that the Black Student Union students are joining us. I know that you made a big trek from Southern Nevada, so it's a pleasure to see you today. Please.
Good afternoon, and thank you, Vice Chair, members of the committee. My name is Anthony Ruiz, and I serve as the Government Relations Manager for NV Energy. I just want to add and echo a few of the important safety aspects of this legislation. As an electric utility, NV Energy is focused on the dangers of balloons coming into contact with our power lines, as was discussed by the Majority Leader, especially the Mylar or foil balloons. During the 2023 legislative session, NV Energy helped pass Assembly Bill 321, now law, which phases out the sale of electrically conductive balloons over time. AB 194 complements that work by focuses on discouraging individuals from intentionally releasing balloons, which remains a leading cause of outages. Especially foil balloons, they can spark when they come in contact with our power lines, causing equipment damage and various outages. And so when a balloon hits a power line, it not only knocks out power for customers, but also creates serious safety risks for the crews that have to work to restore the service. These balloons can melt. Even the non-foil balloons, the typical balloons you might see, can melt into the wires, and they must be painstakingly removed by hand, potentially posing a dangerous risk and a challenge for our line workers. And so despite years of public education on the dangers of releasing these balloons, this remains a leading cause of outages in our state. Just in the past 5 years alone, balloon-related incidents have caused over 400 outages, impacting hundreds of thousands of customers and over millions of dollars in damages. Most recently, on March 2nd, in addition to the Majority Leader's comments in North Las Vegas, on March 2nd, a balloon release caused a major outage in downtown Las Vegas, affecting approximately 10,000 customers. By further discouraging balloon releases, this bill will help reduce preventable outages and improve public safety and reliability for customers across Nevada. And so we appreciate the Majority Leader for bringing this bill forward and just want to emphasize the important public safety issues it addresses. Thank you for your time.
Vice Chair, with your permission, I would now like to turn it over to City Council Member Nancy Bruni.
Good afternoon. It's great seeing you.
Good seeing you. Thank you, Vice Chair and members of the committee. Nancy Bruni, City of Las Vegas. Thank you, Majority Leader Hadagi, for introducing AB 194. NV Energy has done a great job outlining the consequences of helium-filled balloons making their way into the atmosphere. I just wanted to add a couple more data points. The 400 power outages that occurred over the last 4 years affected 600,000 people, which is equivalent to the size of the City of Las Vegas. It also amounted to 190,000 power outage hours, which equates to 7,916 days and 21 and a half years. So this actually is a really serious issue. Additionally, so last year I authored an ordinance to ban the outdoor release of balloons filled with gas lighter than air, which the City of Las Vegas adopted, and it went into effect immediately. I think it's important to note for members of this committee that when we propose the ordinance, the city is required to conduct a business impact analysis. And so we sent out a survey and we received no negative comments from businesses that we surveyed about the potential impact of this type of law. In fact, over time, we've heard growing support from businesses, especially small businesses, because when the outages happen, they really do affect businesses and small businesses in particularly. It is an issue of business continuity. One of the last power outages caused by a balloon getting entangled in the power lines occurred in downtown Las Vegas back in January. We heard that the Beverly Theater had to actually refund tickets because they couldn't show their film, and a lot of small businesses had to throw away their food because they couldn't run the machines to keep the food at room temperatures. And so over time, we've had a lot of support from businesses for this measure. I will share that when I proposed this ordinance, one of my colleagues said it was a great bill, but he wouldn't support it because he thought it really should be taken up at the state level, because a lot of times people don't know if the park they're in is in Henderson or North Las Vegas. So this state bill really would solve that problem. One issue which often comes up with this sort of bill is enforcement. I will say that the enforcement is tricky with many bills. But the real issue here is education and raising awareness. We are currently working with NV Energy to develop a PSA that I think will, to Anthony's point, improve the outreach and awareness. Having a law on the book, however, does make the education and awareness raising efforts easier. We've actually already heard from 2 groups who were going to release balloons to commemorate a special occasion, and once they knew about the ordinance, they decided to celebrate in a different way. So this bill will help. Thank you.
Thank you. With that, Vice Chair, we are open for questions.
Thank you all three for the presentation. It's great to see you, council member. Members, any questions? Senator Ellison, please.
Envy Energy, maybe you can answer this question. Isn't the little bags?
Senator Ellison, I believe your microphone may be off.
No, I hit it. The little bags you can see at the garbage, the grocery stores, you put your groceries in, the little plastic bags. Isn't that more of a threat than these balloons by far?
Anthony Ruiz, for the record, ME Energy, through you, Vice Chair, to the Senator. I have not seen, I don't have any data on that. I haven't heard any situations of plastic bags from grocery stores causing outages. I suppose it's possible, but we do have data, and we have seen very recently Mylar and also non-Mylar balloons cause significant outages. So I'd have to ask our team, but I haven't heard anything to cause that, to know that that has caused outages.
And follow up,
Yes, please follow.
Then the other question I've got is, in the rules, most of the outages are caused by birds or larger birds than is ever a balloon or a plastic bag. Is that not true?
Anthony Ruiz, for the record, through you, Vice Chair, to the Senator. We serve mostly urban areas, but we do have ELCO, for example.
That's right.
I don't have ELCO data on outages, but I will say that an outage in that area would actually, if it were to occur, would be even harder to repair and attend to. So taking the statewide approach, I think, is a good thing, so that we're protected and unified at the state level. And certainly our rural areas could be affected by these type of outages as well. So I could get that data if you're interested and do a sidebar on that, but certainly I think that the threat is there statewide.
Okay, thank you.
Assemblymember Sandra Howdigi, for the record, and I had the similar concerns, Senator Ellis. I had a bill for that in 2017 and didn't get anywhere.
On the bags or on the birds?
Unfortunately, I can't do anything about the birds. It was the bags.
Members, any additional questions? Senator Hansen.
Thanks, Mr. Vice Chair. Question, just talking to the legal guy here. I didn't realize we had a law last session, so I don't remember it, but it's $50 per balloon up to $2,500. Have there been any prosecutions for the law we passed 2 years ago?
Senator Hansen, are you referring to the Las Vegas ordinance or Assembly Bill 321 from last session?
321.
Senator Hansen, I don't have that data on from Assembly Bill 321, but I can ask my co-presenter if the city of Las Vegas has enforced any of their city ordinances.
Thank you. I just found out that is not in effect yet, 321.
Oh, okay.
So the answer is no.
Okay.
But yeah, I'd like to hear. I'm just, if we pass the law, has it done anything in a positive way? Have there been anybody that, actually been prosecuted, paid these civil fines? And also, I'm sorry, I'm not familiar with the Las Vegas ordinance. Could you give us a little short synopsis of what that may be?
Thank you, Senator Hansen, for the question. Nancy Bruni for the record. So our law went into effect last June. I just pulled our latest data from as of this morning from Metro. To date, we have not issued any fines or civil penalties. Our law is structured slightly differently, where the first interaction or encounter is a warning, and then the second one we would follow the civil law penalty structure, where it's a $250 fine, the same as the state law. But again, I think the real issue, we're not trying to prosecute people. It really is, given the very harmful effects on our power lines, business continuity, safety of workers, and environmental concerns. We just want to raise awareness, and so that's why we are working on a public safety awareness campaign that will be distributed statewide. We have had, as I shared in my opening testimony, we have had a couple of anecdotal cases where people have, once they found out about the ordinance, they chose a different way to celebrate their loved ones or the events, which is exactly what we intended to do with the ordinance.
Okay. Well, I'm not necessarily for or against this, but I do want to know if we've already passed an existing law, what the effects have been. So sounds like both of them are relatively new, so maybe in a few more years we'll know, and if we add this one to it, then we'll see if you guys have 400 less outages. Thank you, Mr. Vice Chair.
Members, any additional questions? And I'll make more of a remark. I think the only thing I was trying to figure out in my head is the enforcement / education component of this, and less on the enforcement and more on the education. I know we, for example, my family have a tradition where you release balloons when somebody passes away and you write a message on that, right? So I'm just worried about folk not knowing that they're in violation of the rules. Obviously, that won't happen with my family after this passes because I will tell them. But I am curious, particularly other communities, and especially where the communities may speak different languages, where it's just a cultural kind of phenomenon that they kind of participate in, and that we accidentally miss them because we're not adequately addressing that. But I think, there's a game plan behind that, and obviously with NV Energy being involved, I mean, putting it maybe in the bills. I mean, there's so many different ways that you could help spread messaging and do different campaigns out there. So that was more of a comment. No need to respond unless you want to.
Vice Chair Flores, and I know that City Council Member Bruni had mentioned that there was a couple of organizations, but on the Assembly side when we presented the bill, NV Energy had talked about how they were going to go in and do a public service announcement campaign as well.
And Senator Ellison, I think you had a follow-up.
Yes, sir. When you mentioned that, how different people, honor either the dead or whatever by lifting balloons or whatever. What about the candles that a lot of Orientals do, and they have the little thing, and then they put the notes in it, and then they light the candles, and it goes up. Has any of them been tied to hidden power line? Because when they lift them up, there's a lot of them. There's usually 100 or more. So
I don't have the data on what those like lantern releases,
That's right.
But those wouldn't be covered under Assembly Bill 194, because Assembly Bill 194 defines balloons as those filled with, I'll give you the exact, inflated with gas that is lighter than air, which would not cover those lanterns.
Senator Krasner, please.
Thank you, Vice Chair. If a child on their birthday intentionally releases one balloon to watch it fly up into the air, are they now in violation of this law?
Assemblymember Sandra Howdy, and the goal of the bill isn't to find people and fine them. It's more about prevention, right? It's about getting the education out there. I think you'd have to be knowingly, intentionally releasing balloons, and so I don't envision a law enforcement, whether it be a city or county or the state attorney general, enforcing that kind of bill and finding $250. Ultimately, we write the laws, we don't enforce them. It would be up to the local law enforcement agency, but that's not what we envision. That's not the intent behind the bill. The intent is really to get to the prevention of it.
Members, any additional questions? Seeing none, thank you again for the presentation. I'd like to invite you to sit back in the gallery And at this time, I'd like to invite those wishing to testify in support of Assembly Bill 194. If you could please come forward, Carson City or Las Vegas. Seeing none in Carson City or Las Vegas, EPS, do we have anybody wishing to join us in support of Assembly Bill 194?
Thank you, Vice Chair. If you would like to testify in support of Assembly Bill 194, please press star 9 to take your place in the queue. There are no callers wishing to provide support testimony at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Assembly Bill 194, either in Carson City or Las Vegas. If you could please come forward. Seeing none, BPS, do we now have anybody wishing to testify in opposition to Assembly Bill 194?
If you would like to testify in opposition to Assembly Bill 194, please press star 9 to take your place in the queue. There are no callers wishing to provide opposition testimony at this time.
Great. And then lastly, those wishing to testify in the neutral position to Assembly Bill 194, if you could please come forward, Carson City or Las Vegas.
Good afternoon, members of the Senate Judiciary. Tanya Brown, TONJABROWN, private citizen today for this meeting. I'm a neutral, something that was not discussed, and I think I want to bring it to your attention. And I learned of this 20 years ago. Some people don't know some of the things that I've done over the years, but I established a memorial for our murdered children, in fact, here on the Capitol grounds down in Las Vegas and other counties. While I was down in Vegas, we set off some of the balloons for each of the murdered children. We had well over 100 balloons that went off. What I didn't know at the time was that they had to, the airport had to redo the flights for the jets coming in because of the balloons could get caught in their engines, and that was not discussed here, and I thought that should be brought to your attention as well. Now, on the other hand, I love those balloons, and I can tell you, other than those times, I've never set them off. They go into my house, they stay in my house, and they go flat, and then they go into the garbage. But so I'm in neutral, but I just wanted to bring up about the airplanes. And thank you.
And thank you for joining us. Good afternoon. And I believe the microphone may be off. There's a white button. It looks like a sticker.
There we go.
Perfect.
All right, Drew Teitelbaum, TEITELBAUM, also testifying in neutral. In my personal capacity, although bouncing off the previous commenter, I do work for Allegiant Air, and yeah, anything in airspace is bad for our aircraft. But the comment that I wanted to bring up today is, have you guys considered looking more at the point of sale for this? I actually purchased balloons last weekend for a party with my son and some of his friends. And at Michael's, for example, they already give you a balloon best practices guide for keeping the balloons alive as long as possible. If there are already point of sale places doing things like that, why not just ask them to put disposal best practices on that as well, rather than speaking into the void for however you guys are doing it. Thank you.
And thank you for joining us. Anybody else wishing to testify in the neutral position? Seeing none, BPS, do we have anybody wishing to join us over the phone?
Thank you. If you would like to provide neutral testimony for AB 194, please press star 9 to take your place in the queue. There are no callers wishing to provide neutral testimony at this time.
Great. And Madam Majority Leader, any closing remarks? Seeing none? Perfect. With that, we'll go ahead and close out the hearing on Assembly Bill 94. And next, I do see Assembly Member Roth here. So we'll open up the hearing on Assembly Bill 329. Good afternoon, welcome.
Good afternoon, Vice Chair and members of the Senate Judiciary Committee. My name is Erica Roth, and I represent Assembly District 24 in Washoe County. Thank you for the opportunity this afternoon to present Assembly Bill 329, which revises provisions concerning the fund of the compensation of victims of crime. Joining me today on Zoom is in Las Vegas is Tyler Winkler, supervising attorney at the Legal Aid Center of Southern Nevada's Resiliency and Justice Center. And at the table with me today is Serena Evans with the Coalition to End Domestic and Sexual Violence. Established in 1969, the Nevada Victims of Crime Program, or the VOCP, plays a crucial role in providing financial assistance to individuals who have suffered physical, emotional, or financial harm because of crime. The program helps to compensate victims for crime-related expenses such as medical costs, mental health counseling, funeral and burial costs, and lost wages. To receive compensation, victims must apply within the state's mandated time requirements and report to law enforcement. However, the strict time requirement and mandate that victims share some of their most traumatic moments with law enforcement creates barriers to accessing this essential fund for victims who do not feel safe or ready to seek help from law enforcement or otherwise struggle to navigate the often complex legal system. AB 329 builds upon the important work of the VOCP by making the compensation process more accessible and equitable for victims of crime in Nevada. The changes proposed in this bill will ensure that victims have the time and opportunity to apply for the assistance they need to rebuild their lives. With the Vice Chair's permission, I'll now turn it over to my co-presenter, Serena Evans, to speak to the need for this bill.
Good afternoon, Vice Chair and members of the committee. For the record, my name is Serena Evans. I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. As the statewide Domestic and Sexual Violence Coalition, representing 14 program members from every corner of this great state, we advocate for trauma-informed and victim-centered policies that will increase the resources and support for victim survivors. AB 329 is a crucial step forward, offering common-sense legislation that will reduce unnecessary barriers and improve our state's victim compensation program. The aftermath of an assault or an act of violence is uniquely and deeply personal to each victim survivor. While some may find comfort in contacting and engaging with law enforcement, others may turn to different avenues like victim advocates, a member of their church, or a therapist for help and safety. In fact, domestic violence goes unreported to law enforcement roughly 30% of the time, and sexual assault goes unreported 63% of the time. In 2023, law enforcement recorded 28,698 domestic violence reports, yet NCE-DSV's program members served roughly 34,000. This discrepancy highlights that many victim survivors who may never engage with law enforcement but still need critical support. The Victim Compensation Program can help play a critical role in safety and healing, yet when survivors of violence reach for these support programs, they are often met with bureaucratic red tape, and it is hard to navigate the aftermath of trauma, and their applications are denied due to not meeting the requirements and timelines. There is no one right way to heal from violence, and having the bravery to come forward and seek support in whatever way feels most safe and supportive should not be penalized. And we as a state should not deem victims who are more comfortable engaging with law enforcement as more deserving victims. AB 329 says a clear message. We trust survivors to make the choices that best support their healing. By expanding these types of documentations allowed and extending the eligibility period for compensation, the bill respects survivors' autonomy and ensures they are supported during their most vulnerable time.
Thank you, Vice Chair. I will now turn it over to Mr. Winkler to walk you through the portions of the bill.
Good afternoon, Vice Chair Flores and members of the committee. For the record, my name is Tyler Winkler, Tylerwinkler, and I am the supervising attorney at the Legal Aid Center of Southern Nevada's Resiliency and Justice Center, formerly known as the Vegas Strong Resiliency Center. At the Resiliency Center, I work with a multidisciplinary team to advocate for victims of crime, ensuring they receive the resources and support they need. A major part of my role is helping victims navigate Nevada's Victim Compensation Program, which provides financial assistance for things like medical and mental health care, relocation to safety, lost wages, funeral and burial expenses for families who have lost loved ones. And despite these critical benefits, victim compensation is severely underutilized, in part due to bureaucratic hurdles that prevent eligible victims from accessing the help they need. This bill removes these barriers. Currently, victims must file a police report within 5 days and cooperate with law enforcement to qualify for compensation. This disqualifies many victims who, for valid reasons, don't report their victimization. Research has consistently shown that more than half of victimizations go unreported, and the reasons are varied, including fear of retaliation, distrust of the justice system, shame or trauma, or simply lack of awareness that they could get help if they reported it in the first place. And the result, even though these victims need help, they're denied assistance because of a procedural issue. For example, my client James' story. In June 2021, James was the victim of a violent crime. He spent almost a year in a coma and rehab recovering. And James didn't know about victim compensation or other resources to assist him. And he didn't reach the Resiliency Center until fall of 2023. When I met him, he had a dent in his head. Imagine if someone took an ice cream scoop and just took a chunk out of you, because he was beaten with a baseball bat and left for dead in a parking lot. You know, we could easily access his substantial medical records and EMS reports proving what had happened to him. But because he never filed a police report, he was ineligible for victim compensation. And James's story doesn't make sense. The purpose of victim compensation is to help victims recover, not make them jump through hoops. More importantly, these requirements don't benefit victims or the broader community. Studies show that when victims receive support for basic needs and mental health, they are more likely to heal, more likely to feel safe, and importantly, more likely to cooperate with law enforcement. It does not make logical or prudent sense to create a barrier to recovery by forcing a police report and cooperation before helping them. For example, survivors of sex trafficking are commonly and historically treated as offenders instead of the victims that they are. Compounding the issue, many underage victims have run away from abusive homes or other dangerous situations and unknowingly into the arms of a trafficker. This situation leaves them with one of three choices: return to the original abuse, remain with the current abuser, or self-report to a system they already don't trust and that criminalizes their victimization. This bill ensures they don't have to choose between getting help and protecting themselves. The Resiliency Center is a dedicated staff attorney who serves survivors of human trafficking. Many of our clients are resistant to reporting their trafficker and are often openly hostile to cooperating with law enforcement. However, when a survivor works with us to access community resources and legal help, we have an opportunity to begin healing their trauma. A crucial part of that healing is undoing the destructive narrative that their trafficker has ingrained in them, that law enforcement is the enemy. By providing supportive services first, without demanding police cooperation, we create a safe environment where survivors feel protected. Time and again, once our clients see that they have support and an attorney in their corner, they voluntarily choose to assist in a criminal prosecution. This would not have happened if we had demanded cooperation first. But this takes time. Not every survivor has a trauma-informed attorney to guide them through this process. Encouraging the removal of these unnecessary barriers will support these efforts and ultimately increase cooperation with law enforcement. Now, walking through what AB 329 does, this bill modernizes and improves Nevada's victim compensation system by ensuring that survivors, especially the most vulnerable, can access financial assistance without unnecessary obstacles. It does this by giving all victims 60 months, 5 years to apply, allowing victims to prove eligibility in multiple ways, not just with a police report. It expands protections for minor victims. It ensures that choosing not to engage with law enforcement doesn't stop someone from getting help. I'm going section by section. Section 1, which deals with NRS 217.100, and subsection 1, it extends the filing deadline. Victims now have 60 months or 5 years to apply for compensation instead of just 24 months. It also expands protections for minor victims. Currently, the law says that minors who are sexually abused or involved in pornography must apply before they reach the age of 21. And there's no ability to waive this time requirement. The change here is that all minor victims can now apply until age 26, or 60 months after they turn 21. And now it's clear that even this time restriction can be waived for good cause. And the reason for this is because childhood trauma often delays reporting, and this ensures minors aren't excluded just because they need more time. Under subsection 2, it removes the strict police report requirement. Victims no longer need to file a police report within 5 days to qualify for compensation. Subsection 5, expanding ways to prove eligibility. The current law lacks other ways to prove eligibility beyond the police report. And the change here is that victims can now submit various types of evidence, including medical or mental health records, police reports, if available, but again, not required, protection orders, court transcripts, government records, records from victim service providers, and affidavits from qualified professionals, which I'll talk about a little bit later in the bill, and other documentary evidence deemed sufficient by the director. Subsection 6, defining who can provide supporting evidence. So the new addition here, it clearly lists who qualifies as a qualified third party to provide affidavits or records. This includes doctors, psychiatrists, psychologists, licensed social workers, registered psychiatric nurses, marriage and family therapists, clinical counselors, victim advocates, and clergy members. This expands the pool of credible sources who can verify a victim's experience, making the process more accessible. Section 2 deals with NRS 217.220, and this removes the subsection 1E and eliminates the cooperation with law enforcement requirement. Victims can now receive compensation even if they do not participate in a criminal investigation. In conclusion, this bill modernizes and improves Nevada's victim compensation system by ensuring that survivors, and again, especially the most vulnerable, can access financial assistance without unnecessary obstacles. It keeps strong protections in place while removing unfair disqualifications that prevent deserving victims from getting help. I'd like to thank you all for your time and attention to this important matter, and I'm happy to answer any questions as part of the presentation.
Thank you, Erica Roth. For the record, we are ready for any questions the committee may have.
And thank you all three for your presentation. We'll start off with Senator Hansen, please.
Thank you, Mr. Vice Chair. With the elimination of the cooperation with the police, what the fear I have is, okay, now you've got a pimp who starts pressuring one of his girls to file something like this. I mean, how much are we talking? What is the typical compensation that is awarded, and how do you protect that kind of a situation where you have a girl who's already vulnerable being pressured by an individual who's exploiting her from taking advantage of this when there's a complete absence of law enforcement involvement?
Thank you so much for that question, Erica Roth, for the record. I think one thing that's really important to understand is that this is bringing state law in line with what we already do on the federal level. And so currently on the federal level, we do not have that requirement that a victim cooperate with law enforcement. And so we already have a model to ensure that there is still the proper review of all documentation, which are all legal documents. So, you know, just because they're not necessarily required to get a police report or to cooperate in a prosecution against, in your example, a pimp, doesn't mean that they're not required under, you know, penalty of perjury to provide adequate proof that they have been a victim of crime.
Okay, well, I'm not familiar with the federal law, but yeah, I don't know. It just seems like a little bit of a carve-out that I'm a little nervous about. What is the typical compensation amount? Do you know?
Erica Roth, for the record. I'm going to turn that over to Mr. Winkler since he handles these cases.
Tyler Winkler for the record, and thank you very much for that question, Senator. The Nevada Victim Compensation Program, it has a maximum limit of $35,000. It then breaks that down into specific categories. Really important, and I think this touches on your other question, is All of these benefits are reimbursable. It's not like you apply, you're approved, and they give you a check. You have to show my injury due to the victimization caused this much in medical bills, or I'm going to start seeing a psychologist, or I have crime scene cleanup or funeral expenses to be paid for. I couldn't tell you specifically what the average claim would be. That's something I could get for you at another time or soon.
Okay, well then, right now, you kind of eliminate the police side of it, and then an affidavit of any qualified third-party provider, and you get it all the way down to, somebody in a religious society could fill something like that out. And when you're talking up to $35,000, I could see where this could be fairly easily abused. I don't know, the removal of the police side of it, I understand why, but it seems like that's kind of a necessary check on potential abuse. Is this law on the federal level? Can you literally go on the federal level and have, a priest or something fill out this affidavit, and then the victim could qualify for up to $35,000?
Erica Roth, for the record, thank you for that question. I'm going to let Mr. Winkler speak to the required full list of proof on the federal level, but going back to your original question, is that on the federal level you are not required, it is not required that you cooperate with law enforcement. And the purpose of that is because we have evidence that shows that there are a lot of victims who seek compensation who do not feel comfortable engaging in the legal system. I think the most common and obvious situation is a woman who has been sexually assaulted, does not feel comfortable having those very intimate conversations with law enforcement, but would feel comfortable having those conversations with their psychiatrist or a member of the clergy. There are still barriers, or excuse me, there are still guardrails put in place so that someone can't just claim something without proof that there is compensation required. And they have to be able to prove that the dollar amount that they're seeking is directly tied to their victimization. And that would include proof of medical records, for example, and exactly how much that cost, or the cost of relocating for a member or a victim of domestic violence. And so we have seen already on the federal level that there has not been abuse just because law enforcement are not required to be part of that calculation. But again, importantly, as Mr. Winkler pointed out, we also see that where we allow for services to occur first, for that reimbursement to happen first, we see farther down the line that those victims are more likely to cooperate in a criminal prosecution down the line.
Well, good. Obviously, that's what, my goal is to get the guy that's the jerk in the first place, assuming it's a male, which most of the time it is. But yeah, if you do have the way this thing is, you mentioned legal checks on it, but number 5, section 1, number 5 kind of says anybody that gets an affidavit from a qualified third-party individual could qualify for compensation, and that list is got some people on it that, I don't know, just, especially my idea is some religious person who, fills out this, and somebody goes and says, I was a victim of sexual assault or whatever, and then a priest or something says, well, I'll take your word for it. That's the only check, as I understand it, in that section, because once you get that affidavit from a religious leader, you don't need any law enforcement, and they can apply for compensation, and there is no additional check on making sure it's not somebody just making a story up.
Erica Roth, for the record. So I think that there's 2 checks in there. Number 1, an affidavit is filed under penalty of perjury. So if that clergy member were to file that and believe that they were lying, that's a felony. So that's a pretty serious check on whether or not we're ensuring that people are making truthful statements. It's no different than walking into a courtroom and testifying before a judge or a jury. And second, there has to be additional proof as to what the compensation is for. So if somebody were to come to a clergy member in your example and say, I was the victim of a sexual assault and I need compensation to pay for the medical debt that I incurred, which included, like, let's say a SART exam, and maybe they had some other injury. They would also have to have proof of that. So it's not simply their word telling a clergy member, hey, this thing happened to me and I want X amount of dollars. It's, hey, this thing happened to me. That person files an affidavit under penalty of perjury, the result of lying under which is a felony. And also, here is proof from my medical records that I spent this amount of money on a SART exam. And so there are a lot of guardrails put in place. There's no reason that an individual is more likely to be truthful to law enforcement than they are to the clergy or somebody else that they have more trust in. And so this ensures that we are following what we have already done on the federal level with those same kind of guardrails.
One last question on that, along those lines. If they get the money, $35,000, is there a requirement that they use that to pay off specific debt, or what is the limitations on how that money can be used?
Serena Evans for the record. Yeah, so you have to have documentation of what you're going to use that money for. So relocation costs, medical costs, mental health services. And like Mr. Winkler noted, it is on a reimbursement basis. So that victim survivor has already paid out of pocket, and then they submit to the director in the program to be reimbursed for that, and they have to show proof that that is what the money went for. I also do want to note that there's like caps on how much you're reimbursed for. So it's not every victim that applies gets a blank check for $35,000. It's, relocation costs have X amount, medical costs have X amount, mental health services have X amount, and I believe Mr. Winkler could speak to that a little bit more eloquently than I.
Good, actually, I'm glad you brought that up, because that does make me less uncomfortable with it, because obviously if they have to show it, then it can't go to the pimp, okay? I mean, so that was just kind of like, without the law enforcement, I'm a little bit leery, but that helps clarify it. They have to actually document the bills they've received, and this money will be used to compensate that. Okay, very good. Thank you, Mr. Vice Chair.
Thank you. Next we'll go to Senator Lang, please.
Thank you, and I have some of the similar questions, but I'm interested in, it's actually old language, but it's in section 1, new number 4A and B, and I'm interested in the guardrails on minors, because they can't speak for themselves. Someone's speaking for them and saying, I want this reimbursed, and this. What are the guardrails for minors?
Thank you for that question, Erica Roth, for the record. And just looking at section 4A and B, that language is already in statute. And so the only thing that's changed is looking at the timeline for when someone can seek that compensation. Right now, there is a cutoff at the age of 21, and this extends it more in line with what we do for things like health insurance and things like that, with an understanding that oftentimes young people do not confront what has happened to them for many years and may seek, for example, therapy later in their 20s after they've come to terms with crimes that have occurred to them. And so yeah.
Maybe I could clarify a little. So I understand that it's old language, but if we're redoing the bill, this is an opportunity to update other parts of the bill. And so, as you said, there are minors that bad things happen to them and they block it out of their memory and it doesn't come back until they're older. But I'm just really interested in how, what kind of process we could add to this to ensure that minors, I don't really know how to say what I'm trying to say, but that they have, okay, let's try this. If you had a parent or a guardian and something happened to the child and they may not know or they may find out later, and so they want to help them, I don't see that this particular language, I think it could be enhanced so that the minor would have more help. Maybe it's a clergy person, or maybe it's a counselor at school that can help them. You know, it's maybe not necessarily a parent or a guardian. There are other people that are confidants of minors that I think would be able to help a minor. And I think that it might be an opportunity for us to add some of that into the bill.
Erica Roth, for the record, thank you so much for that suggestion. I will, because I do not practice in this area, I will let Mr. Winkler speak to the process for minors currently, but we are certainly open to, ensuring, and I do think that suggestion is in line with what we're doing for adults, which is saying that, well, you may not feel comfortable going to law enforcement in these initial conversations, and you may feel more comfortable going to a therapist or a clergy member or what it may be. And so I will let Mr. Winkler just speak to what the current process is. I would guess there's maybe some limitations just because they are a minor, and so at the end of the day, there are questions about parental rights and all of that kind of stuff. But I'm certainly open to that suggestion.
And Tyler Winkler, for the record, thank you very much for these questions. Just taking a step back. So all of these benefits, I really want to highlight that they're reimbursable. It might help to think of the victim compensation program. It's more like if you have health insurance. They're not just going to give you a check if you broke your leg. You have to show everything that happened. If you went to the emergency room, the doctors have to submit documents with their appropriate coding. It's the same thing for the things that victim compensation reimburses. For minors, the language in statute basically saying who is financially responsible for the minor. So those people can apply to the program in order to get reimbursed for their out-of-pocket expenses that result from the crime. There is a regulatory piece to this. The statutes, the statute lays out our requirements, and then the department has its own program and all the logistical issues of how they'll accept applications, and that kind of gets into more specifics. I hope that answers the kind of questions that were floating around.
Eric Roth, for the record, and I'm happy to take this offline, Senator, and kind of work through if there is a solution there. We're more than happy to consider that.
Members, any additional questions? Senator Ellison, please.
Thank you, Mr. Vice Chair. Going through there and hearing all the testimony, and on the back it shows it's a 501c3 from the Internal Revenue Service from '86, but this funding, it's federal funding, but what's it under? It's under domestic violence grant, or what's it under? And
Serena Evans, for the record. It's under VOCA, so Victims of Crime Act funding is the acronym used for that, and it's funded through the Victims of Crime Compensation Program within that.
okay, and then what other things can be added to this? Any kind of crime? I mean, like say somebody's going down a road and runs into you in a car and he don't have the right insurance. Does that qualify for this? What I'm trying to do is figure out how big a pot of money that's there, and if it goes, how many states are involved in.
Tyler Winkler, Tyler Winkler for the record. So the Victims of Crime Act established this big pot of money that's populated by criminal fines and fees and forfeitures. It's a multi-billion-dollar fund, and it funds two main programs for all of the states and territories of the United States. One pot of money is for victim assistance, and then the other pot of money is for victim compensation. So every state has a victim compensation program. It's uniquely set up where the federal government provides 75% of the funding. And based on what the state pays, the federal government will increase based on the prior fiscal year. So if Nevada were to pay more claims, the next time we get federal funding, they'd increase it to match. There are specific, so it is limited to violent crime. Things like a car accident, which is negligence, wouldn't qualify. The federal government, the VOCA, is kind of narrow. It just says you have to cover victims of violent crime, and there's a few benefits that you absolutely have to cover, such as medical, mental health, lost wages, but leaves a lot of discretion to the states to increase what types of benefits they'll do, and there's nothing about what the amounts are. I hope that helps explain a little bit more.
Yeah, thank you very much. Yeah.
And Senator Ellison, I wasn't sure if you had anything else.
Well, I think they answered quite a bit of it. The biggest thing is it's a crime fund is what it is. And it looks like this pot of money comes from court cases. Is that correct?
Serene Evans for the record, yes. So VOCA, Victims of Crime Act funding, is funded entirely through federal prosecution and deferment fees.
Okay, and then as they collect it, then it goes back into that pot, is that correct?
Yep, it goes into, Serene Evans for the record, excuse me. It goes into a fund, and then during, the federal appropriations process, they allocate it into the fund annually.
And what if you have, like Mr. Hansen said, what if you have a repeat offenders say it's a domestic violence and it just keeps going on, do they give them one shot at this or multiple shots?
Serena Evans for the record, I would actually defer to Mr. Winkler on that. I believe there is a limit on how many times that you can apply for victims of crime compensation funding.
Tyler Winkler for the record. So that's something that each state would spell out how that would work. In Nevada, currently they treat, if it's the same perpetrator against an individual, they treat it all as one claim. So that would mean it's $35,000 is the max, but again, for the actual injuries that were sustained from it. I hope that answers the question.
Erica Roth for the record, and just as a reminder, and this is only for reimbursements. And so, if there were in an instance a repeat offender, there would still have to be proof that the funding is necessary to reimburse that victim for specific the financial burden related to the violent offense.
One of the things we've seen, like in the Harbor House, women that are victims of rape or domestic violence or whatever, they allow them to go into this home with their families and stay there until they can get things straightened out, but they'd actually be able to qualify there, it sounds like, too.
Serene Evans for the record, absolutely. Yeah, they would have to have, the proof, but working with a victim advocate is actually one of the approved ways of third-party qualification, and they would be qualified to apply for, reimbursement rates for things like relocation fees and medical services if needed.
Thank you very much.
Senator Krasner.
Thank you, Vice Chair. Thank you so much for bringing this good bill. I was just wondering if I could sign on as a co-sponsor.
Erica Roth for the record, I'd be happy.
Members, any additional questions? Seeing none, thank you all for your thorough answers. At this point, I'd like to invite you to sit back in the gallery, and I'd like to invite those wishing to testify in support of Assembly Bill 329 to please come forward, either in Carson City or Las Vegas. I don't see anybody in Las Vegas, so we'll stick with Carson City. Good afternoon and welcome.
Good afternoon, Chair Flores and members of the committee, or Vice Chair Flores, I'm sorry, and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association, testifying in support of Assembly Bill 329, and we'd like to thank Assemblymember Roth for bringing forth this important piece of legislation. Thank you.
And thank you for joining us. Good afternoon. Welcome.
All right, thank you, Vice Chair, members of the committee. Harrison Epstein, legal extern for the Clark County Public Defender's Office, Harrison Epstein. We understand how today's victims can be tomorrow's clients, so we support any and all efforts to prevent the cycle of harm from continuing. Thank you.
And thank you for joining us. Anybody else wishing to testify in support of Assembly Bill 329? Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Assembly Bill 329?
Thank you. If you would like to provide testimony in support of AB 329, please press star 9 to take your place in the queue.
Hi, distinguished members of the Judiciary Committee. This is Robert Gibson testifying in support of AB 329. For the record, ROBERTGIPSON. I am a litigation fellow with Giffords, the public safety organization founded by former Congresswoman Gabby Giffords. I focus on victim services and compensation reform throughout the country. I come to this work, however, as a son of Nevada, moved to action after the 1 October shooting. 1 October united our state, and it brought me to the Vegas Strong Resiliency Center, where we serve survivors. In that tradition, Gifford strongly supports AB 329, a bill that would continue innovations made after the shooting by opening alternative ways to report victimization. Current state law requires victims to report and engage with law enforcement for program eligibility, but this does not account for the realities of crime. A majority of victims don't report to police for many reasons. First, victimization is traumatic. Alongside trauma, survivors are often fearful of being blamed. They have real concerns regarding retaliation, or they lack confidence in the justice system. AB 329 would better account for these realities. Additionally, the public safety benefits of alternative reporting can't be understated. When victims work with third-party trauma service providers, they're more likely to cooperate with law enforcement, and these alternative reports can help repair survivor distrust with police. Further, since most victims don't report, alternative reports will provide the state with a more accurate picture of crime. They'd also play an important role in crime prevention, as more accessible compensation can help to stop cycles of violence. Recognizing the priority of survivor well-being under the VOCA Fix Act, Congress recently changed federal law to clarify that working with law enforcement is not a precondition for compensation. Additionally, the DOJ has repeatedly stated that programs aren't required to mandate victim police reports and engagement. With that flexibility, leading states have opened alternative ways to report, including in Louisiana and in Maryland. This bill would therefore continue Nevada's place among the vanguard, all while remaining compliant with federal law. So, to strengthen public safety and ensure our state is victim-centered, Gifford strongly urges the committee to pass this bill. Thank you.
Thank you for joining us. Next caller in support.
If you have just joined us and would like to provide testimony in support of AB 329, please press star 9 to take your place in the queue.
Good afternoon, Chair and members of the Hardworking Committee. My name is Dora Martinez, and I'm with the Nevada Disability Peer Action Coalition. And we'd like to thank the sponsor of this bill, and we wholeheartedly support this common sense bill. And thank you so much for extending the time to submit paperwork. People with disability are always the last to find out about things, and I hope that there will be a QR code on the website so people who are blind or hard of hearing who uses ASL can have access to this important resource. Thank you and have a great day.
Thank you for joining us. Next caller in support.
Thank you, Vice Chair. There are no other callers to provide support testimony at this time.
Hello, everybody. All right, I think that takes us to opposition on AB 329. Anybody wishing to testify in opposition is invited to do so now, but I don't see anybody coming forward in Las Vegas or Carson City, so we will go to the phones for opposition on AB 329.
If you would like to provide testimony in opposition to AB 329, please press star 9 to take your place in the queue. There are no callers wishing to provide opposition testimony at this time.
All right, then we'll move to neutral testimony on AB 329. I don't see anybody coming forward in Carson City or Las Vegas to give in-person neutral testimony, so we'll go to the phones for neutral testimony on AB 329.
If you would like to provide neutral testimony for AB 329, please press star 9 to take your place in the queue. There are no callers wishing to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony on AB 329, and I don't think the presenters have any closing remarks, so I'm sorry that I missed the presentation. Thank you so much for being here. I look forward to watching it later on the broadcast replay, reruns, you know, things I do in my spare time. And with that, we will move on to our final bill hearing for today. I will now open the hearing on AB 153. Please go ahead whenever you're ready.
Thank you so much, Chair Scheibel. First, I was not aware that you were all down here now, but I want to thank you and Vice Chair Flores and, of course, Chair Taylor, everyone for accommodating me, as I'm supposed to be in 2 different places at once today, as you were as well. So thank you so much. Again, thank you, Chair Scheibel and members of the committee. Good afternoon to everyone. I am Brittany Miller, representing Assembly District 5. And today I am presenting Assembly Bill 153, which potentially could provide additional educational and workforce development for incarcerated persons. A little bit of background information. We know that sustainable, gainful employment plays a crucial role in reducing recidivism and facilitating the successful reintegration of incarcerated individuals into society. So much, in fact, that before I moved to Nevada, I had developed and ran a prisoner reentry program, and the #1 funder was actually the Federal Department of Labor. Yes, Michigan DOJ provided about 25%, but primarily the funding came from the Department of Labor. And why? Because employment is key. We know that it is one of the major factors that, that with education and training and job opportunities, it's one of the major indicators to reduce recidivism. So by equipping individuals with knowledge and skills and educational programs within the correctional facilities, it can significantly improve their prospects upon release. In Nevada, the statewide program of education for incarcerated persons allows school districts, in cooperation with the DOC, to operate educational programs within the facilities. Historically, incarcerated individuals have had limited access to federal student aid. However, recent changes at the federal level have opened up the doors. In fact, even today, there were some visitors on the floor, and they asked me about my bill, and they said, wait, I thought they weren't allowed to. People, while they're incarcerated, aren't allowed to. And I told them that as of July 2023, incarcerated students enrolled in approved prison education programs are now allowed to. And this is the first time since 1994 that they are eligible for Pell Grants which do not require repayment. Incarcerated individuals, however, are not able to obtain federal loans or federal student loans. So the change implemented through the Free Application for Federal Student Aid, or FAFSA as we call it, the FAFSA Simplification Act of 2020 has potential to dramatically increase educational opportunities for incarcerated individuals. One of the keys to the success of the program that I ran back in Michigan was that we didn't wait for release to begin the reentry process. That process began about a year before release in the prisons. And among a variety of needs, education is one that, a variety of needs that individuals need upon release. Education is one that they can begin working on before release. The bill itself, first, it's pretty similar to a bill I had back in 2021, which was to require FAFSA nights in the K through 12 schools. They're supposed to have 2 a year, which enables students to come in with their parents and any necessary materials, and school staff and college and university staff would be on hand to assist families applying for FAFSA. So this is pretty much what this bill is modeled after. So I would also say that this bill is permissive. It is not a mandate at all. It is permissive. So this bill also seeks to have 2 FAFSA events each year as well. Those 2 FAFSA events are around the dates that the government tells us are the most likely when the majority of funds are available, so like October and February. So what would happen is each facility could plan and administer such events in the manner that is most suitable. First, each facility, if not already doing so, should provide career planning, which includes information about financial aid. And with that, with financial aid, we want people to always understand that what financial aid can cover. It's not just college, it's also skilled trains, it's technical institutes and programs as well. So anyone interested in getting, a trade or a certificate program. And that in the prisons, they could get assistance with completing these forms because these forms have become very complicated over time. Individuals should receive this at least once in their final year prior to release or once a parole date has been determined. However, there's no stipulation of when a person can ask for assistance based on their sentence. They can ask for assistance or attend these at any point, but the requirement would to make sure that individuals in their last year of sentencing are aware that they can attend. They can also get assistance in applying for online schools or trainings. Facilities, according to the bill, should also establish a means for family members on approved visitation lists to bring necessary documents and attend FAFSA application events. Again, some individuals are fortunate where their family has documentation and such that would be necessary to apply, and in those cases, enabling people to bring in those documents so their family members can apply. I also am a firm believer in just because we're offering FAFSA to a high school student or an incarcerated individual doesn't mean that the family members can't get assistance and apply for FAFSA as well, as we try to bring the entire family into additional training and certifications. This measure also encourages coordination with our colleges, universities, and even the library district to assist with applications, informational meetings, registration pamphlets, or any other educational or job training. As for the money, because of course that would be a question, I've already stated that individuals are not eligible for federal loans. The money, working with Department of Corrections, they already have been doing something that we want to use as a model. They've done it with Great Basin College, and so that will be the model that we would have for the financial awards. What it means is that once someone is determined eligible, the financial award, and just so you know, also federally, incarcerated individuals will not be able to receive expenses for anything other than books and course expenses. So it wouldn't go for any type of living arrangements. It would just be for the cost of the tuition, the fees, the books and materials, anything like that. So that financial award would go to the school, and the school, if there's a refund, they send that directly back to the Department of Ed. So where a lot of students get refunds and it goes to them, in this case, the refunds go back to the Department of Ed. So the financial aid administrator at each college would pay the student account balance electronically and then send any remainder back to Department of Ed. Additionally, in this bill, another concern that we wanted to address and be proactive about is that any financial aid could not be used for any non-educational expenses such as restitution, commissary, damages, medical technology, anything like that. Also that financial aid or the attempt to apply for financial aid could not be used as a sanction or an incentive for anyone incarcerated. Because again, this is a permissive bill, and it's just making sure that that support is available to any inmate who chooses and desires to apply. So in closing, Assembly Bill 153 represents a significant step toward enhancing educational opportunities for incarcerated individuals in Nevada. By facilitating access to federal student aid and ensuring compliance with established educational standards, this bill aims to empower incarcerated persons to pursue higher education and vocational training. Such initiatives not only benefit the individuals involved, but also contribute to the betterment of society by reducing recidivism and promoting successful integration. According to the National Conference for State Legislatures, currently 17 states have no regulatory or statutory ban on people who are incarcerated receiving state financial aid, and New Jersey has recently expanded access. The implementation of AB 153 underscores Nevada's commitment to and alignment with what other states are doing for what's necessary to reduce recidivism by providing equitable educational opportunities for all its residents, including those in correctional facilities. Moreover, it's important that while supporting individuals with reentry is a public safety matter, it is a prime opportunity to also lessen financial burdens on our state. Part of the reason I brought my first FAFSA bill 2 sessions ago was to encourage more people to apply and access those federal dollars as opposed to relying on state support. Again, workforce development is key, and this is an opportunity to provide an individual approach to accessing that federal support. With that, I appreciate your time and consideration and urge your support of this bill, but I am also open for any questions you may have.
Thank you so much. Members, do we have questions on AB 153? I'll start with Senator Nguyen.
Hello, thank you so much. You had indicated that this language was permissive, but I see in here it says that the department shall do that. So when you say that it's permissive, like would all of these institutions, they would have to provide this? Can you kind of elaborate on the distinction that you're trying to make there?
Yes, thank you so much, Senator. Brittany Miller for the record. The department will be required to offer and provide the information and an assistance night. However, there's no requirement for any individual to participate. So the department will also report to interim judiciary, but their reports, first what they're required to do is, yes, we offered these nights twice a week. I'm sorry, that's a lot. Twice a year. That would be effective twice a week, but that they offered it twice a year and then just report what happened. Whether one person enrolls or takes, accesses the support or 30 people do. But again, we're just asking them to make sure that they provide that information, that that support is available.
And then do you have an idea of already, like are any of the institutions already helping those that are incarcerated with these FAFSA forms?
I believe the one in the north that's connected with Great Basin is. She was available for our first hearing, but I do not believe is here today. So they have a connection, and speaking with the department as well, when they get the tablets and such, that is the goal to have throughout all of the institutions. That would, it would even be at greater rates because then individuals would be able to access more online classes and such.
And then I have a question. It's my understanding that there are some NSHE institutions that currently have programming in our prisons, but do you have that information?
No, I don't.
Okay.
Of which programs is such? No, I don't.
Okay. But I've also heard that there are no existing NSHE programs for our women that are incarcerated in Florence and McClure. Do you have any information about that?
No, Senator, I do not.
I see some
okay,
knowing looks behind you, so maybe during testimony at some point they might be able to answer those questions, Chair, if that's okay, if I can follow up with that. I guess my last question is, you said that there were other states that have this and allow for, I guess, grants. It's not, I'm assuming it's not loans.
There's a federal prohibition against incarcerated persons getting student loans.
Loans.
This is just the Pell Grants.
Just the Pell Grants. Okay, thank you. Thank you, Chair.
Thank you. We'll go next to Senator Ellison.
Thank you, Madam Chair. I'm glad you're back. I do have a couple questions. Number one, what if somebody's in Nevada State Prison and they apply for this? When they get out and they want to go on further with their education, does this follow with them?
Thank you, Senator, for the question. That's an excellent question. That would be the intent, and that's why we encourage it, the offer of support, especially their last year, because again, whatever classes they're able to access while inside, we want people looking forward. And so if they're continuing that education, yes, those grant dollars would continue with them. And it's just that we were able to help them, support them to get that federal Pell Grant.
Okay. And what happens, if they get no federal grant, then how do they support themselves when they're trying to go to school unless they do it at home?
Senator, I believe
you're asking... If you're out of prison and you're going to keep following whatever you're going to do, whatever education you're going to do, it doesn't give you any kind of grant money to pay rent and power bills and stuff like this. So you're going to have money coming from somewhere, and hope they don't go for a lawyer's degree or something, but something smaller.
Thank you, Senator, for the question. I mean, first, it is interesting. A lot of incarcerated people do go for their JDs, but I think that the question, while the bill doesn't address it, is people who are incarcerated are prohibited from getting all of the available federal aid for things that other students may be eligible for, which would be housing and other living expenses, or to get loans. Upon release, then that person should be able to, because remember, you have to apply for FAFSA every year. So upon release, they're now in a different status, so those opportunities would be available to them upon release. And of course, they would also, there's many challenges to ongoing training or college that all students face.
Okay. Thank you very much.
All right, and I think we still have a question from Senator Hansen.
Thanks, Madam Chair. No, overall, seems like a great idea. Question on Pell Grants, is there a payback provision on that when they get released? I don't know how the program works.
Thank you, Senator, for the question. Brittany Miller for the record. The Pell Grants are the grants that are money that is given to the student that is not expected to be paid back at all.
Okay, no, good. That's important because we just had a bill, we have had problems with them getting out. They owe money, they end up not being able to get credit and so forth. Okay, so that takes care of that one. Is this limited to people that are very close to getting out? I mean, I don't see any point in educating people that are lifers, you know what I mean? I mean, is there a window of when they're allowed to apply for these, a couple of years before they're going to be released or what?
Thank you for the question, Senator. It's not limited. It's encouraged that, especially their last year before release, that this is made available to them, but anyone at any time could, access these services. And I understand your thought around, someone who's in for life, and why would we want, someone to go to school? You're never going to get out of prison. I would say, as someone who ran a prisoner reentry program and have been in it, I haven't personally, but my staff, and been in and out of prisons and jails, it can also be used just like a job in prison, right? That by someone being able to focus their energy on education, even if they're never going to get out of prison. Again, these are federal dollars, but it can be something that just personally helps them stay. Because while someone's in prison, even if they're never going to get out, we still want them to behave and conduct themselves in a certain way that's safer for themselves and everyone else around, right? And so a lot of people will find solace in studies, just like they would in music or watching movies or something like that. So I believe it would still be something that we would want to encourage.
Okay. No, well, my concern obviously is when to reduce recidivism rates. I mean, I've been watching this whole time I've been here, my 8th session on Judiciary, and, we have seen a drop in recidivism because we've had a lot of reentry programs, even something as simple as getting an ID, things like that have helped. The only question I got on that, though, is the Pell Grant program, is it a zero-sum game? I mean, is there a limited number of Pell Grants available? And if you're giving a Pell Grant to an inmate, does that mean somebody who's outside of the prison system may not get a Pell Grant?
Thank you for that question. You could look at it essentially like that. When I first brought my bill back in 2021, the one thing we know about Nevada is that the number of students who qualified, we were nowhere, and I wish I had it in front of me right now because I could give you the actual statistics, but we were nowhere near where we should be for even our high school students applying for FAFSA. So we were leaving an astronomical amount on the table. And a lot of it was the misconception of, I don't qualify. We know that there's a major difference between, someone may think, well, I don't get free lunch, so I'm not going to qualify for Pell Grant. But those numbers are completely different. It's a much higher score for families when it comes to Pell Grants. And Pell Grants are also based on income. So it's not every student's going to get this much or not. It would be one student may get 1,000, one student may get 6,000, depending. But it was to encourage more students because students were also relying on our state scholarships, which were designed to supplement and pay the remainder after financial aid. But students were also, well, I'm getting the scholarship, so I don't have to worry about it, which was still putting a burden. So essentially, like any program, we could say that it may take away. Right now, I know not enough and not as many people. Or the other idea that folks didn't realize they could apply for FAFSA, it's not just for college. It's training, certificate programs, all kinds of skill trade. And so we could essentially look at that, but again, these decisions will be made by the federal government and the universities, not by us. And they also would get a smaller amount because they won't get everything that, say, a typical undergrad student would get because, again, we're not covering living and travel and all these other incidental expenses. This is just the course and the required supplies.
Okay. No, overall, it sounds like a very good idea. I'm especially, hopeful of the people that are going to be getting back and reintegrating into society, that they have as much opportunities to be as educated as possible to reintegrate into the workforce and so forth. So, like the idea, got a few little bugs in it, but I think overall it's a great step in the right direction. Thank you, Madam Chair.
Of course. Any other questions from members of the committee? All right, I don't see any, so thank you so much for presenting this afternoon. We will move now to testimony in support of AB 153. It looks like someone is already ready to go in Las Vegas, so we'll start in person in Las Vegas with support testimony on AB 153.
Doug Unger, DOUG, UNGER, President, UNLV Chapter, Nevada Faculty Alliance, and I'm a member of the Nevada Prison Education Project. Thank you, Chairs Scheibel, Flores, and members of the committee. The Nevada Prison Education Project is an independent organization that includes teachers from colleges and universities in the Nevada system of higher education, community groups, justice-impacted students, and the Nevada Department of Corrections. We work together to improve and expand prison education in our state. Our teachers currently work with higher education prison education programs through Western Nevada College, the College of Southern Nevada, and other NC institutions, now also UNLV. We put our first writing class into Florence McClure last spring. Western Nevada College and CSN have completed Department of Education requirements to qualify for Pell Grant forms, all key to enable registrations to take classes in pursuit of diploma, degree, and certificate completions, but these efforts are not nearly enough. Assistance and mentoring to complete the FAFSA, a task which too often presents obstacles for the incarcerated who wish to work to improve their futures, need additional organization and resources. AB 153 offers a solution by further systematizing efforts through the school districts, plus a reporting requirement, which will help systematize efforts and significantly grow pathways toward earning an education. Multiple studies show that recidivism is reduced proportionally to classes completed, diplomas, and degrees earned, and this benefits everyone. AB 153 will add to hope and help change lives. The Nevada Prison Education Project and the Nevada Faculty Alliance stand in strong support and thank Assemblymember Miller for bringing the bill forward. Thank you.
Thank you so much for your testimony. I don't see anybody else coming forward in Las Vegas to give in-person testimony, so we'll come up here to Carson City. Please go ahead when you're ready.
Tanya Brown, Tonja Brown, Advocates for the Inmates and the Innocent. Thank you, Chair Scheibel and members of the committee. We are in support of AB 153. Education offers a pathway for those who have paid their debt to society to re-enter our communities as productive and contributing members. Programs that prioritize rehabilitation, such as education, have demonstrated success in reducing repeat offenses and fostering personal growth. By investing in opportunities for reformed individuals, we can break cycles of crime and create safer neighborhoods for everybody. Thank you.
Hi, good afternoon. Kyle Dalpy. I am president of Western Nevada College here in Carson City, and we do have one of the many prison education programs at the two facilities here in Carson City. We are in support of Assembly Bill 153, and I'm going to quickly just maybe answer a few of the things that come up. Normally, inmates who are pursuing higher education classes in the prison rely on scholarships, which we have through our foundation. They rely on family members or work that they have done and put money in the accounts, or there is also an appropriation through the state that trickles some money into it, and this would give another avenue for access through federal financial aid, which will help pull down some of that aid. As Assemblymember Miller mentioned, we have left money on the table historically from the federal government in the form of Pell Grant to students, and this would help open the door for more of that. And as they get out, I think Senator Hansen might have asked the question on the FAFSA. As they get out, they fill it out 1 year. Every year it has to be renewed each year, and then they can keep it going if they still qualify, and that's how the FAFSA works, which is a very complicated form. I am in higher education almost 30 years now, and every time I fill it out, I have to call my financial aid director. So anytime we can put support around those less familiar, it's a good thing. So we are in support of it. Thank you.
Good afternoon, Chair Scheibel and members of committee. My name is Kylie Cryer, K-I-L-E-Y-C-R-Y-E-R, and I'm an intern with the Washoe County Public Defender's Office here in support of AB 135, which is a critical measure that expands access to educational resources and financial aid opportunities for incarcerated individuals by requiring staff at the Department of Corrections institutions to provide information and assistance in completing FAFSA. AB 135 recognizes education as a cornerstone of successful reintegration and long-term stability. One of the most significant barriers faced by formerly incarcerated individuals is a lack of financial literacy. Financial literacy, the understanding of how to manage money, access aid programs, and make informed economic decisions, is rarely taught and often overlooked. Many incarcerated individuals are unaware of the financial support systems available to them, including federal aid programs that could fund educational and vocational pursuits. AB 135 addresses this gap by ensuring that people have the knowledge and assistance needed to access these critical resources. Financial support is a key component in preventing recidivism. Returning to society after incarceration often comes with immense financial hardships. Without access to tools and resources on employment, budgeting, and financial aid, many individuals and their families struggle to build the stable foundation necessary for successful reentry. A multi-pronged approach is necessary to reduce recidivism rates. Educational and financial empowerment go hand in hand in offering incarcerated individuals a real chance at a second life, and for this, we urge you to support AB 135. Thank you.
Thank you, Chair, members of the committee, and thank you, Chair Miller, for bringing this bill. As you all have heard today, providing information on financial aid to incarcerated people, I'm so sorry, I should start over. Harrison Epstein HARRISONEPSTEIN, legal extern, Clark County Public Defender's Office. Providing information on financial aid to incarcerated people will enhance educational opportunities and give people a better chance at rehabilitation. Holding FAFSA days in correctional facilities will ensure that every person in prisons and jails gets the same chance to learn how they can afford college, trade school, or vocational school as their non-incarcerated peers. This bill will be an important tool in providing these rehabilitative efforts to incarcerated people across the state. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center. We want to thank Chair Miller for bringing this bill. Fines and Fees Justice Center is a proud member of the Nevada Prison Education Program here in the state, and the reason for that is we know that access to education is one of the leading causal factors of reducing recidivism. On top of that, when we increase access to these types of grants for individuals who are incarcerated, they rely far less on expensive other types of courses like correspondence courses, which puts money back into our communities and into the pockets of individuals. And I will briefly touch on, through my time in college, the most difficult thing I did in getting multiple degrees was navigate the FAFSA. The FAFSA office was the land of the most tiers at the University of Nevada. I never filled it out correctly the first time once and had to make multiple trips. These types of days where you have individuals who are well-versed in filling out the packets is absolutely necessary if we want individuals who are incarcerated to get access to these types of funds. We support this bill and hope you do too. Thank you very much.
Good afternoon, Chair Scheibel and members of the committee. My name is Kayla Maese, K-A-Y-L-A-H-M-A-E-S-E. I'm a civil rights analyst at the ACLU of Nevada, and the ACLU happily supports AB 153, and we thank Assemblymember Miller for bringing the bill forward. It's really important that we give our incarcerated individuals the opportunity to do the right thing and to get their lives back on track. Education is such an important aspect of life, and even if someone is incarcerated, let's say for life, it's really important that for say we give them something to do, but we give them the same opportunity to broaden their knowledge as well. So we support this bill and we urge the committee to support as well. Thank you.
All right, I don't see anybody else coming forward in person to give support testimony, so we'll go to the phones for support testimony on AB 153.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide support testimony at this time.
All right, then we'll go to opposition testimony on AB 153. I don't see anybody coming forward in Carson City or Las Vegas to give in-person opposition testimony, so we'll go to the phones for opposition testimony on AB 153.
The public lines are working. However, there are no callers to provide opposition testimony at this time.
Okay, we will go to neutral testimony on AB 153. Anybody wishing to testify in neutral is invited up now. I don't see anybody coming forward, so we'll go to the phones for neutral testimony on AB 153.
Thank you. The public lines are open and working, but there are no callers to provide neutral testimony at this time.
I'm going to see if the members of the committee have any questions for our friends here from, I think you're from the Nevada Department of Corrections. If you have any questions, but I don't see any questions from the committee, so it looks like you're off the hook for today. You don't have to hit the hot seat just yet. And that concludes testimony on AB 153. If the sponsor would like to make any closing remarks, we welcome you back on AB 153.
Thank you so much, Chair, for that. I would just like to also explain, because before the question comes up, part of the reason why it's permissive is understanding anytime that we have expectations of what should happen in our correctional facilities. Obviously, safety is first and foremost for everyone involved. In speaking with Director Zarenda about this, we're both confident that the current internal staff is able to handle this and facilitate it as well. They're more than welcome to coordinate with higher ed and bring people in or work with the library district, but we're confident that the existing staff would be able to do this. And it's also the flexibility from facility to facility of what would be appropriate for their environment. But with that, I thank you for your consideration and appreciate your support on this bill. And thank you so much, Chair.
Thank you. And that concludes the hearing on AB 153. And I think we've heard all of the bills today. I'm sorry that I missed 2 of them, but we have heard all of the bills. That takes us to the last item on our agenda, which is public comment. Anybody wishing to give public comment is invited forward to do so in person now. I don't see anybody coming forward to give in-person public comment. Oh, maybe I do. Okay, go ahead.
Thank you, Chair Scheibel, members of the committee. Tanya Brown, Tonja, Brown, advocates for the inmates and the innocent. I want to ask this committee to consider some of the bills that will be coming before you this legislative session and in the future legislative sessions that are dealing with wrongful convictions, DNA technology, etc. I know that things are already happening down in Las Vegas. It's going to be dealing with the down in Las Vegas dealing with wrongful convictions, and will be one of the topics of conversations going into the 2026 elections. On Wednesday, you're going to be here, AB 63. I will tell you something that I brought before you. It is being sponsored by Attorney General Ford. It is germane to the bill. This deals with, which came out of the committee on the Assembly side, when asked about wrongful compensation for those who've been wrongfully convicted. It does not apply to those who are deceased, and it should. And that, so we have given a proposed amendment I submitted today, and I'm hoping that it will be heard and passed, although it will not have the AG sponsoring it. But it is germane to the bill, and people who have passed away, the family members would receive the compensation for that. And it's, again, just like DeMarlo Berry. If, in his situation, we had an individual, the perpetrator, who admitted to the crime, and that is the reason why he was exonerated. These perpetrators are aging, and they're wanting to do the right thing. I'm not saying a whole, very small percentage, of course. But there are people in prison who've spent time in prison for those crimes and who have died. And so what we've asked for is, and what we've put in the proposed amendment, is to have exculpatory evidence that had been destroyed and has not been turned over to the defense and was not available, resulted in a wrongful conviction, or prior to the defendant's death or after the defendant's death, newly discovered evidence has been found, and that if a person is exonerated posthumously, that the heirs be compensated. And that's what's in this proposed amendment. I'm hoping that you will take this on without the sponsorship of the AG's office. And again, there's a lot of things moving forward for 2026, and a lot of people in office, those who are running for office, wrongful convictions of some of the people, and that's something to look at, is holding these individuals accountable, particularly the prosecutors who withhold exculpatory evidence and destroy individuals' lives. They go on to become district attorneys, Supreme Court justice, and I can tell you that things are in the works now, and it's happening down in Vegas. Thank you.
Thank you for your comments. I don't see anybody else coming forward to give a public comment in person, so we'll go to the phones, please, for any public comment.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting today. Thank you for bearing with us as we got started a little bit late, but we are scheduled again for tomorrow at 1 p.m. And until then, we are adjourned.